hearing, no warning. The Supreme Court just flipped enforcement rules in a way that most Americans didn't even notice at first, but the impact is already spreading across the country. This wasn't a slow-moving decision with months of arguments and headlines. It happened fast, through an emergency ruling, and it quietly altered how laws are enforced in real life. When the nation's highest court moves this quickly, it usually signals that something deeper is going on beneath the surface. At the heart of this ruling is a question that sounds technical but affects everyone. Who actually controls enforcement when a law is challenged? Congress can pass laws, presidents can sign executive actions, but enforcement is what turns words on paper into real consequences. For years, enforcement has often been stopped in its tracks by lower court judges issuing broad nationwide orders. In some cases, one judge could pause a federal policy everywhere in the country, even if only a handful of people brought the lawsuit. Over time, this practice became routine. Supporters saw it as a necessary check on government power. Critics argued it gave too much authority to individual judges. What made it controversial was not just the outcome, but the scale. A single courtroom could effectively decide policy for millions of people who were never part of the case. That tension had been building quietly for years. The Supreme Court's emergency move directly confronted that reality. The majority signaled that lower courts were stretching their role too far. Judges exist to resolve disputes between parties, not to manage national policy. When a court blocks enforcement far beyond the people involved in a case, the court suggested, it crosses a constitutional line. That line matters because judges are not elected and are intentionally insulated from political pressure. The lack of warning is what shocked legal observers. There was no extended briefing period, no televised arguments, no slow buildup. Instead, the court acted through its emergency process, a tool designed for situations where waiting could cause serious harm. By using that process, the justices sent a clear message that the existing enforcement system was not just flawed, but urgent. Not everyone agreed. The dissenting justices warned that limiting the reach of court orders could leave unconstitutional actions in place while cases drag on for years. From their perspective, nationwide injunctions often protected people who could not afford to file multiple lawsuits in multiple courts. Without broad relief, they argued, rights could become uneven and dependent on geography. This disagreement reveals a deeper divide about how the Constitution should work in practice. One side prioritizes strict limits on judicial power. The other emphasizes strong judicial tools to protect rights quickly. The emergency ruling did not resolve that philosophical conflict, but it clearly shifted the balance. Almost immediately, the effects began to show. Federal agencies started reviewing enforcement programs that had been frozen nationwide. Policies that were stalled for months or even years suddenly had a path forward in many regions. State governments began reassessing their legal strategies, both in enforcing their own laws and in challenging federal actions. For businesses, the change introduced uncertainty. Nationwide pauses once offered predictability. Now, enforcement may depend on location. A regulation could be active in one state and blocked in another. Companies operating across state lines must now track legal developments more closely, increasing compliance costs and legal risk. For ordinary people, the shift may feel subtle at first, but it is real. Laws affecting work, healthcare, education, immigration, or voting may now apply differently depending on where someone lives. Two people under the same federal law could face different outcomes simply because of geography. Supporters call this federalism in action. Critics see it as unequal treatment. The majority addressed those concerns by pointing back to constitutional structure. In their view, uneven enforcement is not a defect of the system, but a result of limiting power to its proper place. If laws are unclear or harmful, the solution lies in legislation or elections, not expanding judicial authority. By stepping back, the court placed more responsibility on Congress and the executive branch. This ruling also reshapes incentives. Federal agencies may feel emboldened to act, knowing one adverse ruling is less likely to shut down an entire program nationwide. States may be more willing to test the limits of enforcement. Advocacy groups may need to file multiple cases instead of relying on a single sweeping order. Power has not disappeared. It has moved. Lower courts now face a period of adjustment. Judges must tailor remedies more narrowly and be aware that broad orders could be quickly reversed. Some courts will adapt cautiously. Others may push boundaries. Conflicting rulings are likely, increasing pressure on appellate courts and setting the stage for future Supreme Court involvement. Politically, the decision changes accountability. When courts step back, elections matter more. Policy outcomes become more directly tied to who controls Congress and the presidency. That principle was central to the majority's reasoning. They argue that democratic processes, not judicial shortcuts, should decide national policy. Critics remain skeptical. They point to history, where courts played a vital role in protecting rights when lawmakers failed. They worry that limiting judicial reach could leave vulnerable groups exposed. Whether those fears come true depends on how responsibly elected officials use the authority now returned to them. What cannot be denied is that this happened fast and without warning. The Supreme Court used an emergency tool to quietly flip enforcement rules that shaped government power for years. The consequences will not all appear overnight, but they will unfold steadily. This moment marks a turning point. The old assumption that one judge could freeze enforcement nationwide is no longer guaranteed. The system is entering a new phase where power is more fragmented and responsibility more visible. No hearing, no warning, just a sudden shift that is already changing how laws are enforced across America. No hearing, no warning. And now the real consequences of the Supreme Court's move are beginning to surface, not in headlines, but in day-to-day governance across the country. Once the emergency ruling landed, it quietly reset expectations inside courtrooms, agencies, and state capitals. What looked like a narrow procedural decision is now reshaping how power is exercised and contested in practice. The first place this shift is being felt is inside federal agencies. For years, agencies operated under the constant risk that a single adverse ruling could freeze an entire program nationwide. That reality encouraged caution, delay, and sometimes paralysis. Now, agencies understand that enforcement may continue in most places, even if one court objects. This changes internal decision-making almost immediately, pushing agencies to act faster and with greater confidence. States are responding just as quickly. Attorneys general who once relied on sweeping nationwide injunctions must now rethink their playbook. Challenging federal action may require multiple lawsuits across different jurisdictions instead of one strategic filing. At the same time, states defending controversial laws may find more room to enforce them outside limited court orders. The balance between state and federal authority is shifting in real time. Advocacy groups are facing a reckoning. Litigation has long been the fastest way to achieve nationwide change. That shortcut is no longer reliable. Instead of one case delivering universal impact, organizations may need to fight the same battle repeatedly in different courts. Well-funded groups may adapt. Smaller organizations could struggle, raising concerns about unequal access to justice. For businesses, the new reality is complexity. Companies that operate in multiple states now face the possibility of fragmented enforcement. A regulation might apply fully in one region while remaining blocked in another. Compliance strategies that once relied on uniform federal pauses must now account for geography. Legal departments are already preparing for higher costs and increased uncertainty. Ordinary Americans may not notice the change immediately, but its effects will accumulate. Employment rules, healthcare regulations, environmental standards, immigration enforcement, and voting procedures may now vary more sharply by location. Two people subject to the same federal law could experience different outcomes simply based on where they live. Supporters see this as a feature of federalism. Critics see a threat to equal protection. The Supreme Court majority anticipated these concerns and answered them with constitutional logic. In their view, courts are not meant to guarantee uniform outcomes at all costs. Their role is to resolve cases, not to manage policy. If uneven enforcement causes problems, the responsibility lies with lawmakers to fix the law, not with judges to stretch their authority. This reasoning places new pressure on Congress. For years, legislative ambiguity was often resolved by agencies or courts. Now, ambiguity carries a higher price. If Congress wants nationwide consistency, it must write clearer laws and act more decisively. The court's ruling effectively forces political accountability back into the legislative process. Lower courts are entering a period of uncertainty. Judges must now be careful to limit remedies to the parties before them. Broad orders invite quick reversal. Some judges will interpret this narrowly and cautiously. Others may test how far they can still go. Conflicting rulings are inevitable, increasing the likelihood of future Supreme Court intervention. The political implications are significant. When courts retreat from broad intervention, elections matter more. Policy outcomes become harder to attribute to judges and easier to trace back to elected officials. This aligns with the majority's belief that democracy, not litigation, should resolve national disputes. Critics argue that this ideal ignores reality. They point to moments in history when courts were the only institutions willing to protect rights. They worry that limiting judicial power could allow harmful policies to persist unchecked. Whether those fears materialize depends on how responsibly power is used going forward. What makes this moment striking is not just what changed, but how it changed. No public warning, no drawn-out debate, just an emergency ruling that quietly rewired enforcement norms. The shift will continue to unfold, case by case, state by state. This is not the end of conflict, it is a redistribution of it. Power has moved away from individual judges and back into a system that depends on legislation, enforcement, and elections. Slower, messier, and more political. No hearing, no warning. But a lasting transformation that will shape how laws are enforced nationwide for years to come.